Thank you, Salvatore. My warm thanks to the Autorità and Giovanni Pitruzella for this sunny and optimistic European Competition Day. Sunny because it's Rome, and optimistic because sometimes and often, I would say, building the future brings more enthusiasm than dealing with the present. And to put it bluntly, I like the motto, change and challenges, and that's why our panel should address after the very stimulating address by Joachim Almunia. And by the way, Joachim, thank you so much for being a decisive access of the resounding success of the ECN. We will miss you terribly in our family. Because ambition is our motto, I would say it's not because the ECN has been a resounding success that we should now stop or rest on that laurels. I think just on the contrary, we have to build the future and think about stimulating avenue. And to my view, I think convergence, of course, is the key word, but we have to address that aim, bringing more convergence, I would say, in a different way. Step one of convergence has been creating a network which aims at guaranteeing a uniform application of the same substantive rules, 102, 101, 102. And now I think to have to build for the next decade a new network spirit, a new ambition, which would, of course, keep the first objective, but add another one. And I mean bringing a network, creating a network which aims not only at granting the same interpretation, the same application, but making sure that we have, I mean the NCAs, we have and we use the same instruments to make that rules effective. And Joachim, you are very right in quoting the ECG judgment in the ex-BVK, the Dutch detectability of fines case, where the European Court of Justice made clearly that link between consistency on one side and effectiveness on the other side. So I think we have to switch. Convergence, of course, is important, but convergence is important if and provided it brings effectiveness of a European and national competition enforcement. I will divide my remarks into three parts. Very short words about institutional design of agencies. Second, and maybe a longer development about how to upgrade NCA's procedural toolbox in order to bring that, I would say, instrumental convergence. And maybe the last words would be for the new frontiers we should address in the next 10 years. On the institutional design, I do agree with what has been said by Alexander and by the other speakers this morning. There is a paradox. I don't know why. I mean, European rules protect independence of data protection agencies, of energy or telecom regulators, and have no word about the need to protect independence of competition enforcers. I think there is a need to protect that independence, not only legally, I would say, it deals with the appointment mechanisms and, of course, revocation, but it deals also with the obligation to give that competition agencies the financial and human resource to carry out the tasks which have been assigned to them. So I won't be longer, but France would support the inclusion of that provisions in any, I would say, amendment to Regulation 1/2003, and especially because we have nothing to change in France on that aspect. Second, and I think that's very important, I do agree with what has been said about the need to upgrade, I would say, the procedural toolbox which have been given to all national agencies. I would take three examples. The first one, and it's not a subject which is so much dealt with in conferences, but I insist on that. It's interim measures. The word is used in Article 5 of Regulation 1/2003. It provides that member states have to give the right to their national agencies to order interim measure. So it's enshrined in Article 5 of Regulation 1/2003. To be very frank, we are very few to apply, to use that interim measures for different reasons, which can be due to our legal system, or maybe the fact that the standard of evidence to order such an interim measure is too high. But frankly, we are sometimes criticized for our long investigation, too long investigation, saying, well, you may take very robust decisions, but too late to produce any effect on the markets, which shall be endangered by behaviors. And of course, I mean, that's particularly true in fast-moving technology markets, but also in markets which are liberalized and when there is a risk that incumbent preempts, in fact, territories which could be open to newcomers. In France, that's not to, I would say, to say that we're first of the class, but in France, we have a quite different approach. We think that interim measures is a key element of an efficient enforcement. From 2000, in 14 years, we ordered not fewer than 30 interim measures in very different cases: energy, telecom. We broke contracts. We forced incumbents to change their behaviors. We ordered sometimes innovative and bold measures which stopped strategies, which in fact count on the lengthy investigation to do, well, I can do it, and when I will be fined, well, I've got the result I wanted to achieve. So that's very important. And to be very frank, commitments are, of course, another answer. But commitments, and we have investigation in our portfolio which proved it, sometimes take time as well. So I think we should think about not only saying that we have the right to order interim measure, but maybe harmonizing the standard of evidence we have to meet to order effectively interim measures. And what I see as a very, I would say, encouraging approach is the move in the UK. In the recent legislation, our British colleagues moved from a rather high standard, which was serious and irreparable harm, to I would say, a lighter standard, which is only a significant damage. The second question about the procedural toolbox, which should be dealt with, is the rules about admissibility of evidence. Alexander was echoing that, but it's something practically very important for our enforcement. We have to apply the same rules, especially in cartel enforcement. We have to prove an agreement between, we would call in French, an accord de volonté between companies, and collusive agreement, which is, of course, at the core of the legal standard for proving a cartel activity. But surprisingly, the way that effectively we can get that evidence depends on national legislation, and they are very diverse about the rights we have or not to mobilize such or such practical measures. Inspections are very differently addressed in our national legislation. For example, in France, for inspections, we are subject to criminal law, but for other investigation tools, we are subject to the civil law standard, which in fact, we have the obligation, I use the word in French, we have to respect the principle of loyalty, of fairness. And for example, we have been forbidden to use phone conversations between two companies which had been recorded by the complainant, saying, well, it's not fair to bring that kind of evidence to you. You're subject to the civil standard and not to the criminal standard, so you can't use that evidence. I noted that the European Commission, in the shrimps trading cartel case, was allowed to use exactly the same evidence. So it's a paradox. To deal with exactly the same cartels, It depends on the allocation of case. If the European Commission deals with the case, it has the right to mobilize such or such investigative tool. When it is upon a national agency to deal with the case, it can't. And the result can be different. If we can't bring the evidence, we can find one case and not in the other one. The third element of that toolbox, and I won't be long on that subject, is of course fines. On that subject, we must be, I would say, objective. There is a progress. There is a progress. I remember in 2008, we organized in France, it was sunny as today in Rome, it was in Nice. We organized a meeting of the ECA, the European Competition Association. And France was hosting that conference, that day, working day, and we chose fines as the main topic to be discussed. And I remember very well, John, you remember, you were present at that meeting, we distributed 3 theoretical cases, A, B, C, saying, well, how would you calculate the fines in each of that cases? The results were appalling. There were huge gaps between the numbers we exchanged at the end when we gathered the exercise. There were only, at that time, 5 agencies which took into account for the calculation of fines not, I would say, the theoretical threshold, but the amount of the value of the sales on the market affected by the infringement. Today, I have observed that we are 19 among 28, and not only 5, to start our exercise to calculate the fine from, exactly like the Commission does, from the value of sales on the market affected by the infringement. Of course, that's a beginning, and not, I would say, an end. There is this working group headed by DG Comp and the French Autorité on our fining policy, and we are thinking about giving the instruments either on the soft law and on the hard law in order to bring more consistency. There will be, I think, topics which can be dealt with thanks to soft law, but I think we couldn't escape. We won't be able to escape amendments to to Regulation 1/2003 on some issue. I mentioned, for example, questions about ability to pay, about parental liability, and sometimes maybe the principles when there is a multiple investigation and the same company is fined in different member states. I end my remarks by an optimistic, I would say, avenue. Joachim Almunia mentioned this morning, and I was very happy to hear you, that there should be a reflection, a broader reflection at the European level about maybe transposing the success of the ECN in antitrust enforcement to new areas. And you mentioned the merger area. I do agree. I do agree. That should be our new frontier for the next decade. Why? Because, of course, if we have to think about the internal market, the fact that we punish behaviors, business behaviors, which in fact badly affect competition on that market and endanger the aim of the internal market is of course a key element. But allowing businesses to grow, to buy, I would say, other assets in Europe, in, I would say, a playing field where they have the same rules, not depending on the agency which in fact assesses the case, is quite important as well. And I don't see any true internal market where convergence would deal only with behaviors and not with structures, with the way companies grow and acquire, I would say, or merge with other companies. So I do support your idea. France, Edwin, you mentioned that some could sit on the side of caution, others on the side of ambition, and France is clearly on the side of ambition. We support that idea. It should be something bold, ambitious. We need ambition in that respect, and it should be, I would say, envisaged at the beginning of the new mandate of the Juncker Commission. You're right, the Monti report stimulates our thoughts about that. We delivered in March a report to the Ministry of Economics in France, and the same is now a commissioner within the Juncker Commission. And we started from the See France Eurotunnel case you quoted that morning. We can't be satisfied with the result. That was not a merger. We was notified in 2 or 3 member states, and of course the answer brought by each national agency depends on the market share, on the impact of each national market. It was the same transaction with the same actors and the same impact on the same market, which was notified in Paris and London. The result has been different, and I don't want to judge who is right or wrong, but the answer is not satisfactory. It's not satisfactory because the same company has to reconcile 2 different results, but it's not good for the culture of competition itself. How can we convince our citizens that competition is a treasure they have to share with us if in a country on the same question they have a yes or a yes but, and in another country they have a no? It brings the idea that we are sovereign, and when we say no, we could say yes. So it can endanger, I would say, the legibility of our competition policy, and that's a very, very important step forward we have to do. In my view, we should seriously envisage when a transaction is notified in different member states, it is, I would say, below the threshold where the competition is competent, and we have not to change the distribution of cases between the Commission and member states. When a transaction is filed to different member states, there should be the same substantive rules, the same theory of harm, the same test we should apply, the same timetable, and the same procedural features. I think, of course, it's ambitious, but if we don't succeed on that bold idea, I think we could miss the challenge of our new decade. So clearly, we are on the side of ambitious, and I encourage all those who want to join that ambition to be present today. Thank you very much.